The only felon president in the history of the United States, Donald Trump, has just filed a 96-page appeal trying to undo the New York conviction for the hush money and falsifying business records, where he was convicted a few years back. And the argument is not because he's innocent, but because as president, some of the evidence that came in that case was off limits and it should have never come in. So we're going to unpack the appellate brief that they filed, and we're going to talk about the likelihood of success. Spoiler alert, it's not very high. I'm Sean Kernigan. That's Brian Kabatek. This is Civil Action on the Legal AF Network. Just a reminder before we jump in here on the Trump hush money case and the crazy appeal that they filed. Hit that subscribe button if you like this content. Hit that like button if you like this content. Share this with whoever you might think might find it informative or funny. Brian, where do we start on this issue?
I think a good place to start with this, Sean, is let's remind everybody exactly what happened because so much has happened since he was convicted felon President Trump. I think that's his official title now. Is that this involved Stormy Daniels? This involved the story coming out that he had slept with her, had this illicit relationship, and that there was this money that was paid to her to shut her up, right before the 2016 election.
Yep.
And, it's one of those things that could have changed the election. You don't know, but it's significant. And I think that's something that shouldn't be lost on people in this discussion, wherever you stand on it. It was a significant cover up. So what happened is Michael Cohen was actually asked by Trump to pay her off. And he took out an equity line of credit on his own personal residence and paid her. And then once Trump became president, for several months in 2017, he wrote checks to him, to Cohen. Trump wrote
checks to Cohen, yep, to reimburse him.
Signed them in the White House, right? While he was in the White House. That's an important fact here. And paid off Cohen. So That's the underlying issue. And Sean, just describe what crime that is in the state of New York.
Well, that is called falsifying business records, which is a felony if it's in the first degree. And first degree requires intent, the intent to defraud. And the argument that the prosecutors were alleging here is that this was in the first degree. So there were 34 various felonies. I'm not going to go over every one of them, but basically it all arises out of and is tied to falsifying business records because what the felon in chief did here was he categorized those payments, those reimbursements to Michael Cohen as legal expenses. But we know they weren't legal expenses. He wasn't paying Michael Cohen for his services. He was reimbursing Michael Cohen for hush money that Michael Cohen borrowed himself and paid to Stormy Daniels or to Stormy Daniels' lawyers. And Trump was convicted of this. This was Trump's first criminal conviction, by the way. I can't believe we have to specify which one of the many lawsuits / criminal charges that have been brought against him this is. So this is the hush money felony criminal conviction. Yes, the president of the United States is a felon, a statement when I was growing up and taking civics in grade school, never thought I would have to say. But yeah, so the felon president has now filed an appeal. So I think maybe I should talk next about the structure of how this works. Just as a reminder, this was in New York State Court, and the lowest level, the trial court level of New York State Court is called the Supreme Court, unlike kind of everywhere else in California, where it's called the Superior Court, the lowest level, and in many other states. But in New York, it's the Supreme Court, and now it's at the intermediate appellate court level, which is called, I believe, the appellate divisions of the Supreme Court. And we'll see how it's going to shake out there. And the next stop on the way up is the Court of Appeals, which is New York State's term for their own Supreme Court, I guess, but they call it the Court of Appeals. That's the highest court for New York State cases. So that's where things are procedurally. And just the other day, Sullivan and Cromwell, Trump's lawyers here, filed a 95 or 96 page brief. And we're going to talk about some of the arguments here. Which argument should we start with, Ryan?
Well, before we even get to the arguments, I want to talk a little bit about appellate procedure. An appellate procedure, if you break it down simply, can be broken down into two specific categories. We're unhappy with the facts. We're unhappy with the application of the law. When you start attacking the facts in the appellate court, it's very, very difficult because that's where the jury makes specific findings. The jury concludes that these facts are true, these facts are not true, whatever it is. It's very difficult. So smart appellate lawyers, and Sullivan and Cromwell is a very, established law firm, big white shoe law firm, as we call in the legal world, is really going after the legal issues because they know that that's where, if they have any chance at all, and like you said, in your spoiler alert, the chances here are both slim and none that he's going to get anywhere with this appeal, at least in New York State. He's really going after the legal issues. And the number one legal issue that he wants to go after is the ruling from the United States Supreme Court in July of 2024 called Trump versus the United States, which is amazing as a title. Just let's focus on that for a second. Trump, because I do feel like the entire presidency is Trump versus the United
Right.
States.
That's the theme of the times right now. Yeah. We're in the Trump versus United States era. Yeah.
And so it's not a super narrow ruling, but it is a fairly narrow ruling. It says that when the president of the United States is acting in his or her official capacity, that there's a degree of immunity, a degree of immunity, right? It's
not total immunity, but yeah, some immunity.
But it's pretty high.
Yeah,
it is. Official acts.
It's official acts. It's things he does in his capacity as president. If he directs someone to go into a city and blow things up, for example. If he's doing that in his official capacity as a president, there's immunity. So as Brian said, I think the key issue here, the main question at the center of this appeal, and we'll talk about the other arguments that they've made, because usually on appeal, you have one big theme and you throw in a bunch of other arguments too. So the main question
his argument.
Go ahead.
Yeah, go ahead, Sean. I'm sorry to interrupt you. Okay,
sure.
I'll go ahead. Fine,
You say it.
His main argument is basically, look, I signed these checks in the White House. They were, while I was president, I was signing these checks, so you can't come after me. So this is reverting to his argument that he made in the Supreme Court, that anything he does while he's sitting president, he has complete and total immunity for. And under that theory, he could argue, he could, execute Melania one day and say, well, I did it while she was sleeping in her bed in the White House, and you can't prosecute me.
Yeah.
And I mean, it's right. It's funny, but it's like that is the extension of his argument. Well, the problem here, Sean, is these acts, the predicate here, which we call sort of the origin, all took place in October of 2016. The agreement took place in October of 2016, and his quote unquote official act is he's sitting behind the Resolute desk in the White House, in the Oval Office, and he's signing, his crazy signature. He's signing checks. That's his official act. That's what he claims his official act is. So most people, including, the two of us here, think that is probably a non-starter. Now, I want to talk about this at the very end. How does this ultimately get to the United States Supreme Court? But let's put that on hold for a second. Let's anything you want to add to the immunity argument?
Well, I want to point out, I want to focus on some of the timeline there you just described. This all starts in October of 2016 in the lead up to the 2016 election, which is why they needed so desperately to make Stormy Daniels be quiet. And that's why the hush money was paid then. So it all comes out of that. So it's a very tough argument to say that the reimbursement of him sitting in the office and signing checks to Michael Cohen to reimburse it and then categorizing those as legal bills. I don't see how that's an official act. I don't see how that's something he's doing in his capacity as president, because the whole thing stems from Donald Trump, the presidential candidate, in pre-November of 2016 taking place. But anyway, let's go on to some of the other arguments. Brian, which one do we dive into next?
Well, I want to go into, maybe one of my favorite arguments here is that he actually argues in his brief that Alvin Bragg, the district attorney of New York, the district attorney of the city of Manhattan, really, that this was a targeted prosecution, that he was going after Trump for a vendetta, and that is completely prejudicial and inappropriate. You can't pick on somebody because you have a vendetta against them. And that in and of itself is inappropriate, and you can't engage in a prosecution like that. Now, Sean, I don't know if you're one of the smartest people I know. Can you hook a link between that and anything else?
No.
I can.
What else is like that, Brian?
I mean, it's dripping with hypocrisy and irony, right? I mean, right now, he's admitted that he's going after. Yes, I know you know. He's admitted that he's going after. He's going after Comey. He's going after Letitia James for a vendetta. Yeah. And he is the most
vindictive. This is like the height of hypocrisy. It's like, oh, this was a politically motivated charge or a case that the DA brought. And it's like, oh, really? You know somebody else who does that? You, the defendant in this case, the one who was convicted, the convicted felon, has a tendency to go after people with political motivations. So that's interesting. My favorite argument that they make is about the judge in the case. They argue that the judge should have recused himself because the judge has a huge conflict of interest because he made a $35 donation to a Democratic cause in 2023. That's
not to Trump.
Not to Trump, to a Democratic cause, not to a candidate running against Trump, just to a Democratic cause, $35. And they argue that the judge should have recused himself because of that.
Right.
I don't know.
I mean, these arguments that they're making are very thin. They're let's say their best argument really involves this immunity argument from the Trump versus United States case. So I wanted to finish by talking about the fact that how does this ultimately potentially reach the United States Supreme Court, where, no surprise, he's packed the court with Trump supporters and who at this point seem like they're willing to do anything he wants at all. And here's how it reaches it. So right now it's in the state court system. And that's a problem for Trump because in the state court system, he's not dealing with the handpicked judges. He's not dealing with, the system that he's tried to rig. But once the highest court in New York rules on it, Sean, he then has the right to file a petition for certiorari, for review before the United States Supreme Court. Now, in the interim, he's tried to remove this case to federal court and it's failed. He's trying again. It's failed. It's going to go through the New York system. It's also going to take a while. Let's be honest.
But once it gets to the New York Court of Appeals, which I said is the highest court in the land of New York within the state court system, then he can, probably lose there. Then he can appeal to the United States Supreme Court. But as Brian said, he has to file a petition for that. It's not a guaranteed review. And part of me thinks when we were first reading this brief and talking about it, the immediate reaction that Brian and I both had was, I bet you that the immunity issue is front and center. So that could be the hook for having the Supreme Court review it. Otherwise, they would have looked at, some of the other evidentiary issues that they talk about, kind of more nuanced procedural things, procedural and evidentiary issues they're nowhere near as compelling. Not to say that the immunity issue is compelling, but they're not that interesting. They don't have a lot of merit. That's why this thing is front and center, so they can make it attractive to the Supreme Court and judges and Trump's handpicked judges on the Supreme Court. I mean, what do you think, Brian? Is that why it's set up this way?
I think that's right. I think one thing, my last comment on this, as we wrap it up, is remember the real winners that came out of this case are now Judge Emil Bovee, who was one of his lawyers, and Todd Blanche, who's now the number 2 person in justice. These were his lawyers. So, I've been a lawyer for a long time, and we don't win every single case. I've lost a couple of cases in my career, jury trial cases. I've never been appointed to a high-ranking official position because I lost a case. I want that on the record. In exchange for
losing the case, yeah. Well, maybe keep your phone on. Keep your phone near you. Maybe Trump will call you. No, he's not going to call you.
No. Okay.
Well, this is an interesting issue. We'll let you know when we see the response briefs to this and how the Court of Appeal or the Intermediate Appellate Court rules in New York, and we'll see how it shakes out. Should make for some interesting stuff. Interesting legal issues, at least, to discuss. I'm Sean Kernigan. That's Brian Kabadik. This has been another installment of Civil Action on the Legal AF Network. A reminder, if you like this content, hit that subscribe button, hit that like button. Share with us your comments and feedback. We actually read this stuff. If you have questions, reach out to us. We're both practicing lawyers. We're friendly. We're really nice. Even Brian's nice sometimes. So we're here. And thanks for tuning in. We'll see you on the next one.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.